You're listening to a Frequency Podcast Network production.
Well, thank God you have the prenup.
I have no prenup.
You have no prenup.
I have no prenup.
You have no prenup.
In the 2003 Coen Brothers rom-com, Intolerable Cruelty, George Clooney plays a divorce lawyer who specializes in prenuptial agreements that protect rich men from so-called gold diggers. And that is probably the image most of us have of what a prenup is and what it's for from pop culture. There's also a scene in that movie, by the way, where Billy Bob Thornton eats the prenup that he had his fiancée sign, as an act, I guess, of romance and devotion. It's kind of sweet. These days, though, most of us don't have much gold to dig. So, what exactly is the point of a prenup in this economy? I'm Jordan Heath Rawlings. You're listening to In This Economy, the show where we help you understand the systems that create your money problems, from grocery bills to marriage contracts and everything in between. This episode was suggested by a listener named Brogan. We got our colleague Dom to read his email for you.
Hello, I love the podcast. I'm also a family law lawyer. I'm seeing lots of millennials these days fall into the trap of getting married, common law or officially, without a prenup. This mistake usually means they have to spend way more on a lawyer to fix the issue down the line. This seems like interesting content you may want to explore.
Like I said, the main perception of a prenup is something you use to protect yourself from a gold digger. But in this economy, most of us don't feel like we have enough gold to bother protecting. But if you are at the point in your romantic relationship where you're thinking about intertwining your finances, there still are plenty of things to think about. So we are turning to Georgina Carson for her take. She's a family lawyer and a partner in the firm Carson, Chousky and Lein. Georgina, why don't we just start with what people think they know or what they assume when they hear the term prenup? I think for a long time, for some people, it was, the sign of something you get to protect yourself from a quote-unquote gold digger. How off base is that?
Oh, well, no, that's still a common refrain, a common expectation. But and the word prenup, obviously it's a short form for prenuptial, which implies that there is a pending marriage.
Right.
But in Ontario, what we call any kind of domestic contract that's made either before or during a marriage is a marriage contract. And if people are unmarried, they can still enter into a domestic contract, and that would be a cohabitation agreement. So sometimes if people begin to cohabit, but they're expecting to get married in the future, what we'll draft is a cohabitation agreement, and then that morphs into a marriage contract once they're married. Interestingly, I was talking to a lawyer in Manhattan a week or so ago, and he was telling me that you can't do that in certain parts of the state. It's a very bright line between cohabitation and marriage, but in Ontario, it can be one-stop shopping.
Just so I get this straight, you enter a cohabitation agreement when you start dating and you move in together. You get married, nothing changes. That's still all legally binding, at least here.
Well, some cohabitation agreements only deal with issues that may arise on the dissolution of an unmarried status. But if it goes on to speak about, these are usually in fairly plain language, so it says if we get married, then the following rights will apply or the following terms of a contract will apply, because there are things like net family property and issues arising in a marital situation that are different. So if the contract anticipates that, then it can cover all the bases.
I'm going to ask you this before we start. I know you have a stake in it, but I'm going to ask it anyway. Do you recommend these contracts for everyone?
No, I actually hate marriage contracts and cohabitation agreements. Hate is a strong word. As often as not, when someone comes in to see me, it's a very valuable consultation, because what I dish out is a great deal of legal understanding, because there's a lot of misperceptions out there. And so people often come to me thinking, the minute they cohabit or the minute they marry someone that they have to share half their stuff, and that's not the law at all. So oftentimes my job is just giving people the lay of the land of the law in Ontario. I think it's interesting that people are allowed to get married without any understanding necessarily of what would happen if the marriage ends. And frankly, people make life decisions throughout the course of relationships, often with having no idea of the legal consequences if the relationship is to end. And face it, every relationship ends by either separation or death. Not to be too pessimistic, but that's the reality, right? Is that a relationship is going to end in one way, shape, or another. And it's good to understand what happens in those circumstances.
So what are some of those common misconceptions that you hear from people when they come for a consultation? You've already covered the he gets or she gets half my stuff right away one. What else?
Yeah, so it's really important to know that in Ontario, and I keep saying in Ontario because different provinces have very different property rights.
I was going to ask about that. And before we begin, maybe clarify this. You're speaking specifically to Ontario, but in this interview, we're going to cover things that aren't specific details, but sort of general knowledge around what happens when and what you should think to do to protect yourself. But how much does this vary across Canada?
Well, property rights are a provincial domain, so they can vary quite a bit. For example, in British Columbia, if people cohabit for, I believe, 2 years, they have the same rights as married spouses, whereas in Ontario, the property rights under the Family Law Act never apply to unmarried spouses, even if people have cohabited for 40 years. So that's a distinct difference. But there are many similarities as well. But I do want to qualify anything that I say with respect to property rights that it's Ontario-based. The Divorce Act is a federal statute that applies across the country, of course. And so parenting rights under the Divorce Act and support rights for married spouses, those are governed by federal legislation, first and foremost. Yeah. But unmarried spouses have rights in Ontario to support under the Family Law Act. But interestingly, in Quebec, there are no spousal support rights for unmarried spouses. So it's a very, very distinct difference in that circumstance. But one important thing, and I'm always happy to tell people this when they come to see me about a prenup or a marriage contract or a cohabitation agreement, is that if you're married and you come into the marriage with substantial wealth, because a lot of times it's a different generation that wants the couple to get a marriage contract, right? That wants to protect either family money or family wealth or the expectation of inheritance, things like that. But when people come into the marriage with assets, and often you see this when it's a second marriage or a third marriage, people who may be in their 50s or 60s or even older that are getting remarried, and they're coming in with quite a bit of wealth, and they say legitimately, they say, look, I've got adult children. I want to make sure that even though I'm, happily getting married for the second time, that my children are going to be able to inherit.
Right.
And so what I'm always happy to tell them is that under the law in Ontario, spouses are able to deduct the value of the assets that they bring into the marriage. So if someone comes in with significant wealth, then they get credit for that. The only caveat to that is that if you bring a matrimonial home into the marriage and you're still living in that home at the date of separation, you would not get a deduction for it. But, a lot of people say, that's great. Thanks for coming out. And they leave my office. No contract necessary, right? What I do tell people, and this is important advice, is if you're starting, especially a marriage, that it's really a good idea to memorialize what you have, especially if you have, quite a few more assets than the other spouse, to just keep records, right? Keep bank records. Banks don't keep records for more than 6 or 7 years. Keep evidence of what you bring in, file it away. But the reality is that, one thing that's hard to prove 20 or 30 years down the road is what you had at the date of marriage. So that often is good advice and people go away. But I generally give people an overview of the law, of all the laws that could affect them at separation. And the other thing that is important to know, that people in Ontario cannot contract ahead of time about parenting or child support because those are rights of the children.
Right.
And then the other thing that you cannot contract about in a marriage contract in Ontario is Part 2 rights under the Family Law Act, which are basically rights around the matrimonial home. So a person who is married cannot sell the matrimonial home, even if it's in their name alone, without the other spouse's consent. They can't mortgage it, they can't transfer it, they can't gift it. They have to have the other person's consent. And most importantly, in many ways, the other spouse continues to have the right of possession after the separation until there's an agreement or court order otherwise. Because back in the bad old days when, and I'm talking a really, really long time ago, if a man owned a home, technically, if he decided to separate, he could change the locks.
Right.
And that's why they brought in that law, frankly, is just to protect women and children. But it's an important possessory right.
So how much does a typical cohabitation agreement or prenuptial contract cost? And I know you mentioned people come in for consultations. Those are free, but then what happens next?
So sometimes consultations are free and sometimes people will charge, 1 hour. And for example,
Okay.
sometimes I'll have a 2-hour consultation, but my rule of thumb is to charge for 1 hour because it's super important and it's a really, really valuable dispensation of legal advice. But actual contracts can vary so much. I mean, in some cases, there's multiple trusts and corporations and this kind of thing where the disclosure is the tail that wags the cost dog, if you see what I mean.
Mm-hmm.
But because the disclosure is so important, there's a real focus on that. And for good reason, because only with the disclosure can people make truly informed decisions. So the cost can vary a great deal, but getting that initial advice is, in my view, the most valuable hour of legal advice you might ever get, whether it's at the time of cohabitation, the time of marriage. Certainly, if anyone separates, they should absolutely get legal advice and enter into a comprehensive agreement with full financial disclosure. Because unfortunately, a lot of kitchen table agreements are botched, and a lot of time is spent in the future trying to fix botched agreements.
We're going to talk mostly today about planning in advance and how to take care of whatever finances you do have when you're entering a cohabitation or a marital agreement. And I guess the answer to this is probably that it varies, but we're really just talking about romantic relationships here and the contracts that go with them. At what point does a romantic relationship become a legal contract with rights for both people?
So I think what you mean is a change in status, a change in legal status.
That's
Because
right.
a contract is a written document signed and witnessed and dated. But I
Right.
know what you mean. And what you mean is a change in legal status. And you're absolutely right. Frankly, it's confusing in Canada because there are different definitions for different statutes. For example, under the Income Tax Act, if people cohabit for 1 year, they're considered spouses. If people cohabit for 3 years in Ontario, they're entitled to claim spousal support under the Family Law Act. In Ontario, as I say, you could live together for 40 years and you'd never be entitled to make property claims, but there are other claims that unmarried spouses make against property, including trust claims and equitable claims. And under the Family Law Act itself, in 2 different sections, the definition of spouse is different. So, for example, for property purposes, you have to be married. That's part 1 of the Family Law Act. It says spouse means a married person. Under Part 3 of the Family Law Act, spouse does not mean married.
Huh.
It means people who are married or people who have lived together for 3 years or had a child together. Because if people have a child together, that period of 3 years can collapse.
Right.
And you could be together for a much shorter time. So you can imagine the confusion that this brings in the world.
I mean, I'm confused right now. So when you have people come to you then for a consultation, what are some of the things that you typically see them, and I'm not talking about misconceptions here, but mistakes you typically try to guide them away from, or mistakes that they might have already made when in dealing with one another and their finances when teaming up, at whatever point we are here in the legal status game?
Yeah. So I think a lot of people believe that if they remain unmarried, that may simplify things. And, if it's a short-term relationship and there's no children and there's no dependents and there's no intertwining of finances, yes, that's pretty straightforward, right? But the reality is that the longer the tenure of an unmarried relationship, the more complex it can be. And frankly, the lack of the statutory certainty around property can make it really muddy and complex. So, if someone comes into me and says, oh, well, I'm in an unmarried relationship, so this will be really easy, I generally disagree. Well, it depends on the circumstances, but generally that can be the opposite because there are many equitable claims that are available for unmarried spouses, including joint family venture claims and trust claims and equitable claims and all sorts of things. So staying unmarried to try to make things simpler is not always the case, and that's a common misperception. Another common misperception is the idea that equalization of net family property on marriage breakdown is that everything gets divided in half. That's wrong. Someone could have a net worth of some substance, like millions of dollars, but it might be they brought a lot of money into the marriage or a lot of value into the marriage, and or they received gifts or inheritances after the date of marriage, traceable to assets existing at the date of separation, and therefore they're excluded. So I've had cases where, one spouse's net worth might be $10 million, and then their net family property is zero because everything is either deducted or excluded. So it's a different analysis. The other common misperception is that every asset gets divided in half, and that's incorrect.
Right.
In Ontario, it's a scheme where one spouse will owe the other an equalization payment. It's like a transfer payment based on whichever spouse has the higher net family property. And that whole calculation can be it can be very complex, not to put too fine a point on it. So, assumptions should not be made. Everyone should get legal advice about that. And then finally, a very common misunderstanding is that it doesn't matter whose name a matrimonial home is in because they always get divided in half. False, wrong. That is, ownership matters. There's nothing in the Family Law Act that transfers ownership of a matrimonial home. If someone comes in with a matrimonial home, they might leave the marriage with a matrimonial home. The matrimonial home has special attributes and is treated somewhat different than other assets, but at the end of the day, it is not automatically owned jointly.
So far, we've talked a lot about homes that are owned and wealth that is possessed. And I don't know if you've listened to this show or looked around at the younger generation these days, but people getting married don't always have all that stuff. So I want to ask you about debt. What happens to somebody's debt when they enter a common law agreement, cohabitation agreement, or of course a marriage?
So that's a really good question. So gone are the archaic days where someone was responsible for their spouse's debts. However, the reality is that when people are in a relationship and their finances are increasingly intertwined, people sometimes get, understandably, sucked in, for lack of a better word, to either consolidate their spouse's debts, or if a spouse has credit card debt that they're paying some horrendously high rate of interest on, and they're saying, well, I can't pay the mortgage because I'm paying for my credit card, then often the other spouse will assist. And that's, relationships are partnerships, and that's all well and good. But don't underestimate the power of that, right? That people often end up contributing in many, many ways to their spouse's debt load. Sometimes that's taking on more of the family expenses. And sometimes it's consolidating debts, which frankly is a prudent thing to do. I'm not criticizing it. But, there's nothing that legally says, okay, the minute you're married or you cohabit for a period of time or anything, that you're responsible for those debts. And sometimes people just can't get financing, right? So their spouse has to sign on to a car loan or whatever it might be. I think one of the best words of advice for people who are in a relationship and looking to the future and starting to integrate finances is really be open and transparent, right? Really be open and transparent with each other. Make sure that you tell your partner the good and the bad.
Right.
I have a case right now where my client had no idea that her husband had huge gambling debts, and she kept paying things off for him. And now she's found out that he was even defrauding her extended health benefits. He was submitting false claims for foot care. Thousands and thousands and thousands of dollars of alleged foot care, right? And, she says to me, how did I get into this situation? And the thing is, love is blind, and people will put up with a lot. And sometimes in a situation like this, In that case, she's left holding the bag, and frankly, her job may be in jeopardy. It's a very sad situation.
Would a prenup have prevented that? And do prenups automatically come with full disclosure? Is there a discovery process around a prenuptial contract that would reveal things like this? Or is this contract still dependent on the good faith and disclosure of both parties?
Okay, no, that's a very good question. So in Ontario, the standard for a contract, prenuptial agreement, a marriage contract, a cohabitation agreement, and even a separation agreement, to be valid and enforceable, there must be full financial disclosure. It's a positive obligation on both spouses. And the most common way a contract is found to be invalid is that there was insufficient disclosure at the time of its negotiation. So it's a really important foundation. It's very different from someone, say, buying a business. Yes, they have to do their own due diligence and things like that. But at the end of the day, it's somewhat buyer's beware. In family law, there's almost a fiduciary duty on both spouses to make sure that everything is disclosed. So someone is entering into a marriage and they're coming in with a lot of debts. That's really important disclosure to be made and would presumably come out in the context of a contract negotiation. But frankly, anybody getting married should make sure they have a very good handle on their spouse's, situation. And again, a lot of it comes back down to being open, transparent, sharing goals and expectations. And I think it never hurts for somebody to get legal advice when they're anticipating their legal status is going to change, because information is power. And just knowing the lay of the land, knowing the basics of the law. I mean, nobody's got a crystal ball. And I think that's another fundamental sort of misunderstanding about these agreements that are made at the beginning of a relationship or during a relationship, is that no one knows what the future holds. And there may be twists and turns. And these contracts try to anticipate and help with the resolution of issues at the end of a relationship. But frankly, sometimes they can make things more problematic because people look at them at the end of the day and say, wow, this is a really unfair agreement. It didn't seem unfair when everybody was signing it, when everybody was in love and about to get married. But now it's turning out to be really unfair and or sometimes unconscionable. And it's not uncommon for marriage contracts, especially, to be overturned because they're inherently flawed in some circumstances. And so people need to be really mindful. And the other thing is, though, getting some legal advice and then going through a relationship mindfully, right? Knowing that if you own a property jointly, these are going to be the effects of joint ownership.
Right.
Knowing that if one receives a gift or inheritance after the date of marriage, that if you keep it separate, then you may be able to exclude it from your net family property. But, a lot of people say to me, oh, if I'd only known, I wouldn't have taken my inheritance and paid off the mortgage. And what I say to them is, that was a prudent thing to do. There was nothing wrong with that. And frankly, I've had cases where people hiving off their inheritance has led to a relationship breakdown, right? So, I think just having a better sense of the law, people, make decisions as they go along, and that's a lot healthier and it's a lot fairer, because then people aren't sort of sucker punched when they find out that they've made all sorts of decisions and either a contract's not upheld or that they simply didn't understand the legal foundation on which they were standing.
So when I asked you off the top if you recommend these for everybody, your response was very visceral and you said no. When do you recommend them? Give me a sense of when a relationship moves from something that is basically covered by the statutes that exist and the way things are done to one that you would say to the people sitting in front of you, yes, I think you guys should have a contract.
The simple ones are the best, in my view, because they're simple and they're understandable and they can only help. For example, if someone comes to me and says, well, I'm bringing a home into the marriage. We, are hoping to stay there for a very long time. And I say to them, well, look, one sort of, in my view, unfair thing about the Family Law Act is that you would be denied a date of marriage deduction for bringing this in. So why don't we just do a simple contract that says, if there's a separation or death in the future, that if you're still living in this home, that you will still get a date of marriage deduction for this home, even though the Family Law Act says that in the normal case you wouldn't. Simple. Like those kind of contracts, I have no problem recommending. It's contracts where they're for example, totally separate regimes of property where people contract out of the Family Law Act. They say, okay, what's yours is yours and mine is mine. I like that. That's simple. It's understandable. And when I recommend those contracts is often for people who are entering into their second or third marriage, right? Who are basically, they've already had a life with another spouse who may have died. They may have adult children and they're entering a different phase of their life. And so is the other person. And so they're basically just saying, look, we love each other. We want to get married, but we want to sort of keep everything for our families of origin or just keep everything separate. And I have no problem recommending that. There's full financial disclosure, as you pointed out. And that can be helpful too. It's good for people to be open and transparent when they're entering into a relationship. I mean, sadly, I've had cases where once the negotiations are underway and the disclosures made, the relationship ends. And I sort of think, well, that's really sad. On the other hand,
better now than later.
Right. Yeah, exactly. I agree with that.
What about more unusual forms of cohabitation? Could you use something like this contract for, say, a polyamorous throuple or something like that? And how would that change? And I'm guessing there are not rights provided under Ontario or Canadian statute for polyamorous relationships. How do you navigate those?
So, I think people have to recognize that most contracts are dealing with the end of a relationship, right? Or relationships, as you point out.
Sure.
If people are involved in polyamorous relationships and say they buy a house together, or they've got something that needs to be addressed on relationship breakdown, because that's when these contracts are invoked or triggered. So that would be kind of more like a property contract, right? And so I think it would be wise, especially when there's more stakeholders at the table, to have clear ideas of what would happen if things went awry and one person wanted out. There's a house, it's owned by 3 people or 4 people or whatever that are in a relationship together, that there be a simple contract that basically said, okay, well, if one person wants to sell the house, then rather than bringing an application under the Partition Act, this contract might have a shotgun provision or a right of first refusal provision that the other parties could buy the house or things like that. But you sort of have to think, okay, well, what's the intent of the contract and what is it going to address in future?
Let me ask you this then, now that I've just asked you a really weirdly specific question. I made you talk a legal loop around me. Give me the 3 things that you would tell a couple that they should do as they prepare to tie their finances together for what is hopefully going to be like a really long period of time.
So I think the best advice would be open and transparent, talk about goals and expectations, because frankly, lots of relationships break down because people, as it turns out, who knew? They have very different goals and expectations, right? I mean, I deal with cases sometimes where people find out years after marriage that the other spouse didn't want to have children. Well, surely that should have been discussed ahead of time, that kind of thing. It's amazing to me how often people just don't communicate. So that's really important. But then life happens, right? Like a lot of people, they start out together, they're both rugged individualists and they're maybe both professionals or they're both working. But then as time progresses, they might have children with special needs that nobody anticipates that, right? Nobody plans for that. And then suddenly one person is devoting a lot more time to childcare and has to give up their work outside of the home, and things really change, right? I mean, needless to say, I'm not critical of people who are in situations where life happens and things change and it's unexpected, or a spouse becomes disabled,
Sure.
right? Those are things that are very unpredictable. But when someone has just very different, I again had cases where one spouse will say to me, as soon as I got married, I didn't really want to work again. And I say, well, did you talk to your spouse about that? I mean, it's amazing to me. Now that's rarer, certainly in this day and age, but it's sharing goals and expectations are really important. And then thirdly, I'd recommend, like anybody anticipating a change in their legal status, whether they're becoming longer term unmarried spouses or getting married, it's always helpful to understand how the law works and how it may affect them, not because they're necessarily anticipating a relationship breakdown. I think it makes for a healthier marriage, right? Or a healthier relationship to sort of know, okay, we're in this together. Marriage is an equal partnership. That's been deemed by the Ontario legislature since 1986. And let's plan together. Let's be very open and transparent and share our goals and expectations. And that really is the best takeaway.
Georgina Carson is a partner with the law firm Carson, Chousky and Lein, where she practices family law. Thanks so much to Georgina for sharing her expertise. You can find more information about Georgina's services by visiting cclfamilylaw.com. And of course, thanks to Brogan for writing into the show with this episode idea. We need more of those from you folks, so don't be shy. If you have a money problem, we want to hear from you. You can email us at hello@itepod.ca. You can call us and just talk it out into thin air. Leave a voicemail. The number is 416-935-5935. And as I always say, we don't need your real name, but we do need your real numbers, whether those are financial numbers or if you don't have those, just an actual phone number so we can call you back. That would be great. Thank you all so much for listening to this show. We love making it for you. And if you want us to keep making it, first of all, we need more topic ideas from you guys because we're running out of them. The bucket's getting a little bit low. If you don't write in, I'll have to resort to solving my own financial problems in a very self-serving way. If you like this show, if you want more of this show, and we hope you do, the best way to do that is to spread the word. Tell your friends, tell your family. Take their phone and forcibly subscribe them to this podcast. That's totally fine. We will not complain. Seriously, though, you could just like and rate and review and subscribe and follow or whatever your podcast app lets you do to show your support. I'm your host and executive producer, Jordan Heath Rawlings. This episode was written and produced by Allison Broverman and Stephanie Phillips. Our sound design was done by Christy Chan. Mary Jubrin is our digital editor. Diana Kay is our manager of business development. And together, we make up the Frequency Podcast Network, which is a division of Rogers. Thanks once more for listening, and we will talk again next week on In This Economy,